Well, good afternoon and good morning, everyone, and welcome to Thrive in 2025, monthly webinar series brought to you by ArcPoint Labs, your single source employer solutions provider that empowers business leaders to create compliant, high-performing, safe, and healthy workplaces that thrive. Today's Thriving Thursday topic is workplace drug screening, the importance of policy, procedures, and job descriptions. My name is Ryan West, your host and Thrive specialist, and honored to be sharing the virtual floor today with two experts and legends of their craft, attorney Bill Judge and his managing partner, Nick Hartman. But first, three brief announcements. This webinar is being recorded, and the recording will be posted to ArcPoint's website by end of day tomorrow. So if you'd like an encore yourself, or you think a colleague would benefit by listening to it, simply visit arcpointlabs.com, click on the Employer Solutions page on the navigation menu. You'll see a drop down, and then click on View Webinars. Second, ArcPoint is proud to be a recertification provider with HRCI and SHRM. So if you are a credentialed HR professional, you'll receive one RCE and one PDC at the end of today's session. But you must attend the entire session to receive these credits and also a certificate of attendance. And lastly, we invite you to spend just a moment of your time at the end of today's session to complete the post-webinar survey. A survey link will be posted in the chat towards the end of the hour. Simply click on the link, follow the prompts, and know that your honest feedback is valued and sincerely appreciated. If you haven't already, please go to the chat to say hello. Let us know where you're logging in from. And also perhaps maybe list one or two things you'd like to learn from our presenters today. No doubt there's going to be some questions. To make sure that your questions are seen and answered, please use the Q&A function for your questions and use the chat for everything else. Introducing yourself, sharing comments, maybe a short story relevant to the topic today. But if you have a question, please try to use the Q&A. That way we don't miss your question. And with that, it is my pleasure to introduce not one, but two industry heavyweights from Drug Screening Compliance Institute, Mr. Nick Hartman and attorney Bill Judge. Nick is DSCI's managing partner and senior consultant, who over the past 2 decades has helped design and manage drug-free workplace programs for thousands of employers, both here in the US and also internationally. Bill is the senior research attorney and co-founder of DSCI with nearly 40 years of experience, whose work from the trenches of drug and alcohol testing law continues to influence national policy. On a more personal note, for those of you who are just now hearing about Nick and Bill, both are deeply respected and trusted thought leaders when it comes to compliance, education, advancing best practices in the drug and alcohol testing industry. So very proud to continue our partnership with DSCI. And gentlemen, welcome back to another webinar with ArcPoint. The floor is yours.
Thank you, Ryan. Very kind.
Very flattering, Ryan. Thanks for pumping us up. I appreciate it as always. Thanks to the ArcPoint Labs family and family of franchisees for allowing us to speak today. As Ryan mentioned, my name is Nick Hartman, the managing partner and lead consultant here at the Drug Screening Compliance Institute. And joining me is my business colleague, Bill Judge. While Bill is an attorney, we're not going to hold that against him in today's conversation. We're going to, but please understand that DSCI is not a law firm. ArcPoint Labs is not a law firm. Everything we're going to be talking about today is for general information purposes only. As you can imagine, everyone's situation is unique and different, as are their compliance requirements. So certainly encourage everybody to seek guidance prior to taking any action based on the information that we're going to cover today. I got a nice agenda for you to kind of lay out the land of why policies, procedures, job descriptions are holding so much more weight now than ever before. We're going to talk a lot about what you should have in your policy, some guidance and strategies, and some considerations as you go to craft or review your policy. Talking a lot about mandatory and voluntary laws, things you need to consider when you go to craft your policy to make sure that it's compliant. Talking a lot more about procedures and job descriptions again, and with the weight that they hold these days compared to years past. And then, of course, we'll end with some takeaways. from the conversation. Certainly welcome your questions as we go throughout today's conversation. As Ryan mentioned, please use the Q&A box. We'll be happy to field those as we go throughout the conversation and have some time carved out at the end to answer those. It was great to see everybody throwing their location in the chat. Hello to everybody, my local Pacific Northwesterns enjoying a beautiful day out here, but seeing people from all across the U.S., it's nice to see. So hopefully this information resonates to you, as it obviously is applicable across the board, no matter where you're joining us from today. All right. So we're going to start off with policy, talking more about strategy, guidance, and considerations. And Bill, you and I, we get these calls all day long, right, about customers that need help with something happened, something hit the fan, a situation happened, they want to know how to proceed. They go to look to their policy and they're even confused as exactly what they should do and if whether it complies with the changing laws, right? So when we talk about policy, give them the strategy that we typically approach, especially for those multi-state employers out there trying to grapple the changing rules and regulations.
Yeah, first, I guess first what I'd like to communicate is the fact that we're going to be talking mostly about state laws today, non-regulated, non-DOT rules that apply. Federal DOT is relatively static. There are some changes since 2018. If you haven't updated your policies related to DOT type tests since 2018, you really, really should let us help you look at those. There's not only some additions for drugs that have been added, there's 4 synthetic opioids that were added, but a lot of people miss the fact that there are significant changes to the MRO procedures that you really need to take a look at. But when people come to us and ask us to help them with policies, either to create a policy for drug testing or to upgrade their policy and update it, we basically explain that our position is that you want to have a core company policy, which basically is like the kitchen sink, and no rules that tell you who you can test, when you can test, and what you can test for. It's what do you want? Okay, that's the first question that needs to be answered. Then, depending on where you're operating, we would add state-specific rules, state-specific addenda to those to that core company policy. The days of having a single corporate approach to drug testing are gone. You just can't do it. And that's because there are too many state and local rules that are different, that apply to your operations. And I think you'll see that as we go through this conversation. You also need to have, there are many, many states, for instance, that require written policies, and we're going to explain a couple of those states, Minnesota and I think Oklahoma. There are states that require signed acknowledgments from the employees or the applicants that are participating in your program. We're firm believers in checklists. I just sent yesterday to a very large corporation our reasonable suspicion and post-accident checklists. When trouble happens, when things happen, people, it's a lot easier for you if you can just go right down a checklist instead of having to think about, oh God, what should I be doing here? So we also, finally, on this slide, we're absolute believers in education and training. With marijuana and the changes that marijuana legalization brings to your company's program, it's absolutely crucial that you talk about training your supervisors regarding the concept of reasonable suspicion. So we'll talk a little bit about that too.
Yeah, it always baffles me a little bit. You get customers that pay to have their policy done, a great written policy, and then they shove it in the top desk drawer and then never really sees the light of day until something happens. And then whether or not it's relevant, whether or not it's up to date and compliant is the other thing, right? And then you have the conversations with companies that stand on their haunches that they have a zero tolerance policy, that it's a nationwide coverage policy. What we always let those clients know right out the gate is you made the right phone call because you're a litigation target. You need to fix this today. You need to correct this today, right?
Yeah, we don't want any of you to become defendants, folks.
Yeah, exactly. So again, as Bill mentioned, really starting out with your core company policy, whatever you wished, if there were no rules at all, addressing federal, state, local, different requirements via state policy addenda, etc. So Bill, when we start to craft the details of the policy, of course, you're going to have your philosophy, right? The why. Why are you conducting drug testing? Mainly, we see this out of safety. Obviously, safety in our nation's workforces is primarily um, the goalpost there, but there could be other reasons, contractual requirements, etc. You start out with the who. Who are you going to be testing? Who does your policy apply to? Is it all employees? Is it all just safety sensitive employees? Is it a specific business units? That's where you'll describe in detail who the policy applies to. What prohibitions you're going to have? What substances are you going to be testing? What other situations would trigger a testing event? Where testing is going to take place typically, when's testing going to take place. This is a hotly contested item that we're going to talk a lot about today, whether some employers choose to do pre-hire testing or not, or whether they have a robust post-hire testing process with like reasonable suspicion post-accident, those types of things. Detailing what testing methodologies that you're going to use for conducting testing, what sample types you're going to use. We're going to talk quite a bit about that. And there was a question that I already saw in the Q&A box on how you balance legal drug use with workplace safety. And we're going to hopefully talk quite a bit about that and answer that question. And then finally, consequences. What are the disciplines you're going to impose for policy violations? Are you going to treat someone the same if they possess a prohibited item versus being potentially being under the influence or showing signs and symptoms of workplace substance use? It's important to detail exactly what's going to happen and what consequences of those actions will be imposed so that your employees and obviously your supervisors and managers can understand. All right, so we kind of talked on some of these things, but I just want to divulge in a little bit more detail the statement of the policy, right? Every single day we deal about workplace safety. I think everybody on this call can agree that if someone is under the influence of an illicit substance, whether it's legal in the state or not, in the workplace, they pose a big threat to those employees, to the general public, their clients, etc. So workplace safety is almost always the cornerstone of conducting workplace drug and alcohol testing, but it could be client driven, could be contract driven, could have other prohibitions or requirements if you're trying to comply with state drug-free workplace programs, different contracts, grants, all the rest of that type of stuff, right? Applicability. One thing I wanted to point out here is whether it applies to all applicants, employees, and whether you're going to, and you'd absolutely need to discern between those employees that are regulated at a federal level or under DOT regulations versus those that are in a non-safety sensitive or a non-regulated role and what the different rules are. How are you
Nick,
going to handle? Go
on
ahead.
that score, yeah, we frequently talk to employers who will tell us, well, we're a federally regulated company.
Hmm.
So we follow federal rules, but every regulated company in the country has non-regulated workers. And so the rules that apply to those non-regulated workers are different. You have to understand that.
That's right. You can't rest your laurels on the fact that you have some regulated employees and then apply that to everybody when clearly that doesn't work. Bill's famous for some cases that he's ruled and won that quickly. That's what the lawyers call low-hanging fruit when they start applying federal laws, federal rules to non-regulated individuals. So,
Absolutely.
you know. Notice of a policy. We're going to talk a lot about some different state requirements, some oddities that are out there. Some states require employers to physically post a notice of the policy so that everybody can have access to it. Prohibitions. Again, we're going to use terms like illicit drugs and prohibited substances, but marijuana obviously skates the line, whether it's prohibited or illegal or not. Alcohol, of course. Again, how do you handle potential use versus possession? Those are all going to be important things to detail. And I mentioned earlier that what we hear a lot from our clients is when testing will take place. A lot of our clients are asking us, should they consider stop screening for cannabis pre-hire? Bill Judge and I both agree on this, even though he's the lawyer. Sometimes we debate on these things. We absolutely resoundingly think that employers must continue to screen for marijuana
There's
pre-hire.
there's a handful of jurisdictions, New York City, Philadelphia, a couple of others, where you can't test for pre-employment marijuana. Okay, but There are safety sensitive carve outs, even in those jurisdictions. But other than that, that's all. I mean, most of the states that have any limitations whatsoever basically say you can't discriminate against somebody for like their off-duty use of marijuana, which we'll get into. But
Yeah.
we are firm believers in continuing testing of marijuana, and then if there's a positive, then you discuss what to do.
Yeah. In most all situations, employers across the U.S. are allowed to screen for marijuana pre-hire. Now, the limitations are where how you handle that positive drug test, and that could vary by jurisdiction, which we'll get into some of those details.
Right.
But what about collections lab confirmation? Do you use an instant test? Do you send it off for lab confirmation? Do you send someone to a collection site, to one of our ArcPoint locations and have their collection professionals handle it and send it off to the lab? Do you use an MRO? All of those things need to be considered and are industry best practices for workplace drug testing. How are you going to handle dilute specimens or those that are unable to provide a specimen within the 3 hour time limit at the collection site? We're also going to talk a lot about employee assistance programs or providing an avenue for those that have a substance abuse problem to go proactively seek help and secure their position in the workplace. Drug testing is not a gotcha program. It's not a, oh, we got you, now we're going to terminate you. There's no rule, there's no law out there that says you must terminate someone because they tested positive for an illicit substance. So there's certainly more. Of our clients are open to things like second chance agreements, offering treatment, an avenue for treatment, and returning back to the workplace to secure that valuable employee. Same thing for disciplines, offering different various reassignments or whatever the case might be. We talked about the notice of rights. If someone tests positive, they go through the MRO process. A lot of states dictate that they have the right to appeal those results, what the timing is involved, and all the rest of that, which we'll go into.
Yeah, some people may not be aware that in non-regulated testing, there are 14 states or programs in states that require the use of an MRO.
It's a fun fact, and Bill, you would always say that you actually don't have a drug test result until
I
an MRO's reviewed it, right?
I believe you absolutely have to have an MRO as an attorney. And if you discipline somebody and you didn't have an MRO, first question I would ask you if you're in charge of the program is when did you get your medical degree?
That's right. One of the cheapest insurance policies employers can have with workplace drug testing is having an MRO part of that program. Employee education, supervisor training. Again, you can write the best policy ever, but if it's not adopted, if it's not understood by those that enforce the policy or those that the policy applies to, then what's the point? So make sure you're providing that education on the dangers and impacts of workplace substance use, the details of your policy to your managers, supervisors, and to your employees. And then, of course, company contacts. Who's the designated employer representative at your company who manages the workplace drug testing? Who's your HR and safety contacts, legal contacts? All those things should be detailed in a company policy.
Now,
All right, go
when you
ahead, Bill.
talk about the policy and in the detail, here are some of the additional considerations that you must consider. States where you work, the rules are going to differ. Okay, so your policies, your state addenda, which we strongly encourage you to think about, would take into consideration the differences in the rules state by state. What's the nature of the states you're talking about? And we're going to cover this in some detail. What do we mean by the nature of the state? And we're talking about the difference between a mandatory state with mandatory rules or a voluntary state where you can take advantage, financial advantage, of some statutes and some programs that exist. What about the case laws and the agency decisions in those states? How does the work comp commissions in your state react to marijuana in the workplace? And now, of course, we'll talk about, you should consider the DOT requirements that apply if you have drivers or other DOT required testing. One of the areas that is going to fast grow, I believe, being driven by marijuana issues are state human rights disability discrimination laws. These are not something that employers typically think about, but they're going to become increasingly important. What about client or contract requirements? Keep in mind that if you've got a client, say you're a contractor and you've got a construction project and the owner of the project says, well, we want drug testing done this way. If state law disagrees with that, you're bound by state law. Just keep that in mind. And there are plenty of court cases that say that. Now, I've already mentioned the voluntary programs. What about ADA? We had this come up just yesterday with a customer, and they weren't aware that the ADA does not protect medical marijuana patients. Plenty of court cases across the country that say so. Why would that be? Well, keep in mind, marijuana continues to be a Schedule I prohibited substance under federal law, and the ADA, the Americans with Disabilities Act, is a federal program. Obviously, therefore, it provides no protection to medical marijuana patients. What about OSHA? A lot of people still have old rules related to the 2016 OSHA pronouncements, which no longer apply. So that's something you want to take into account. Union and collective bargaining agreements. This has changed lately. If you're not aware of what I'm saying when I say the Weingarten rights protect employees, you need to talk to us. Okay, because there are certain things that you have to be aware of and to allow your employees when it comes to testing on reasonable suspicion. Keep it simple. We've got a policy we just got yesterday that we have to review and update. It's 71 pages long. Hey, folks, your employees aren't going to read it. So, don't do that. Our policies are typically around what, Nick, 7, 8, 9 pages?
Try to keep it under 10, Bill. Yeah.
Very simple. We want simple approaches to things so that your employees will at least read it and be aware of what they have to do. Emerging technologies. For us, oral fluid testing is the greatest thing since sliced bread. And we'll explain to you why that is, but we're absolute believers in the use of oral fluid testing. In fact, even DOT is. They've got rules prepared. As soon as they get 2 laboratories that can do the testing, they're going to launch those oral fluid test options. But even DOT says that they believe upwards of 42% of all DOT tests will eventually be oral fluid testing.
Yeah, and there's other emerging technologies that we are tracking out there, of course, like proctored collections, different cognitive or fit for duty tech or apps, or the goggles, or all these different new tech solutions that are coming to our industry, which is great because we need evolution, but you need to make sure we understand the applicability of those and defensibility of those different technologies. So, this is what we call our wheel of testing compliance, but these are all the different issues that an employer needs to consider. And when you go to craft your policy, when you go to craft your program, all these things need to be taken into consideration from several different aspects. And we're going to cover quite a few of these topics. But for Bill, when we talk about, you mentioned the nature of the state. Let's dive a little bit more. We're going to touch on each one of these in detail, but at a high level, we talk about case law and state law. Kind of paint the picture of it for us here.
Yeah, sure. We're going to get into this in some detail. There are mandatory states, and we have now, Nick, 31 mandatory states, I believe.
Sure.
What these are states that have rules that employers must follow. It's not a question of may. It's a question of if you're going to do drug testing, okay, great, but you got to follow that state's rules.
Yeah.
Then there are voluntary programs. There's a handful, 4 or 5 different types of voluntary programs, including workers' comp discount programs. There are 12 states that offer like 5% annual discounts on your work comp premiums if you follow their rules in terms of testing. Rebuttable presumption of intoxication rules. There are now 21 states that have such rules. Workers' comp programs where you can defeat a work comp claim. Unemployment is considered a voluntary program where you can attempt to defeat someone's unemployment claim based on a positive drug test. So it's in the mandatory states, you got to follow them. The voluntary states, you want to follow them because that's where the money is, folks.
That's right.
Then there are required states. There's about 31 states that have positions like home health care workers, public works construction projects, even more. My favorite, of course, is the North Carolina. They have bungee cord operators where if you're in those positions, then you must have a drug testing program.
Yeah,
And
and
then
really,
yeah, go ahead, Nick.
I was just going to say the biggest emerging one, obviously, that drives our conversation today is the emergence of marijuana laws and how they differ from every state and differ by jurisdiction in some cases. We're going to talk about immunity laws. There's laws out there where if employers simply follow the rules in their state, they're immune from lawsuits. I'll repeat that again. If they follow the rules, they're immune from lawsuits. That, again, a free insurance policy there. And then, sadly, a shrinking number of states that we consider open states that have no rules, where employers are just simply following best industry practices. But as we track today here at DSCI, there are well over 1,000 state drug testing laws, and there's hundreds of municipal laws that impact workplace drug and alcohol testing, and well over 25,000 court and agency decisions that then go and make case law and create a legal precedent for employers that are conducting workplace drug testing.
Yeah, by the way, we are averaging about 1.5 new court decisions a week.
Yeah. And whether some of those, and lawmakers are constantly passing new or proposing new laws, and it goes through the legal works. Most of those die off, but some of them do become law. And then, of course, we have to digest what that means and how it impacts workplace drug testing. So, as Bill mentioned, mandatory laws. If you're in a state that has a mandatory drug testing law, that could be by state statute, regulation, or a court decision, you must follow those rules if you wish to conduct workplace drug and alcohol testing. It's not an option. So again, for multi-state employers, this is incredibly impactful on what those rules are and how you're addressing them by policy and your internal procedures. As Bill mentioned, 31 states, several cities have mandatory drug testing requirements. And Bill, makes sense of
Yep.
this colorful
Well, I
map
just
here.
want to make sure everybody understands how we classify a state as mandatory. So, for instance, the yellow states, those are mandatory because of drug test compliance laws. Like Iowa, for instance, Iowa's had a mandatory drug testing statute since 1987.
Mhm.
Okay. I was involved in the first U.S. Supreme Court's drug testing case, and that was in 1989. So the Iowa statute predates even the first U.S. Supreme Court decision permitting testing. The
Yeah.
green colored states, those are obviously, we're trying to be clever here. Those are mandatory and have mandatory rules in their state's legalization of marijuana laws. The orange states or the rust colored states have both mandatory drug testing statutes and marijuana laws. And then the blue state, Virginia, it has a law, interestingly enough, that basically says employers cannot discriminate against an employee's off duty use of CBD. Frankly, we're not quite sure why that exists, but
We don't test for CBD or
we don't test for
cannabidiol in
CBD, but
workplace
there you
drug
have
testing.
it. It's
Yeah.
you can't discriminate because of it.
Lawmakers felt that it was important to include in there. So, as you go through all this, just to share some oddities for you to kind of put a lay of the land here. And again, this is just a drop in the bucket, but some states specifically require employers to have policies and require them to be written. Iowa, Minnesota, Oklahoma, as example. Maine has that requirement as well. Not only is Maine requiring you to have a written policy, you must use their template, and it must be approved by the state Department of Labor before you can start conducting workplace drug testing.
One
Uh,
interesting thing about Maine, however, is if you are within the state of Maine and you have even a single DOT regulated employee, you do not have to comply with Maine's rules.
yeah, so that's a little caveat there. There are states that limit or prohibit who can be tested, whether you can test pre-hire, post-hire, whether there's limitations to testing only safety-sensitive employees. States and municipalities that limit or prohibit what substances you can test for and what cutoff levels you must use. Oklahoma has very specific rules as to limiting drug testing to schedules 1, 2, and 3 substances. Do you know what those substances are? And then states now that we'll talk very briefly about requiring you to screen for Delta 9 THC versus marijuana metabolites. States and jurisdictions that limit or prohibit when testing can be conducted, whether it's again pre-hire or post-hire. Some states limit or prohibit when testing can or where testing can be collected. Some states limit or prohibit the use of rapid or oral fluid, or sorry, rapid or instant drug tests. They require lab-based testing. So that's again an important differentiation to understand. Some states limit or prohibit how testing is conducted, what testing methodologies, what specific collection procedures must be followed, or the type of discipline an employer can impose. This is probably the biggest and most impactful is what happens after
There's,
a positive drug test.
there's about 7 states that basically say you can't fire somebody the first time they test positive. And there was a court in Minnesota that ruled that a medical marijuana patient probably can never be fired. Think about that. And by the way, we have charts on most of these things.
There's requirements on timing. There's requirements on notice and forms that must be used, who pays for drug testing, how to dispute results. Just know that, again, this is just a drop in the bucket of the different oddities that are out there. And that's a whole other webinar in of itself. But
Right.
for the purpose of time, Bill, we want to make sure we get to these couple of
Yeah,
different slides so we talk to the content of it, right? So
and this,
where it stands today.
yeah, where we are today, and we kind of squeeze things together into this single map, just so you know. But right now, there are 38 states and Washington, D.C., and some territories that authorize the medical use of marijuana. Now, I've seen other authorities, other sources that say, no, we're up to 40 states. Well, people look at things a little bit differently. So just be careful. But according to our research, 38 states have specific statutes and rules or constitutional amendments that detail how the authorization of medical marijuana.
Yeah.
There are 24 states plus Washington, D.C., and some others, other territories that authorize the adult use of marijuana. We don't talk about recreational use. That's a whole nother story. We talk in terms of adult use of marijuana. 18 states have authorization of the medical use of cannabidiol, CBD, or as they say in Iowa, low dose THC oils. Okay. Each of these states' rules are different, vastly different. There are some commonalities, but many of these states have differences and little nuancy things you got to be aware of.
Yeah, one of the biggest trends, and we're talking about this as you go to craft your policy, you have to consider marijuana laws because this is probably the most rapidly changing in the legal landscape of workplace drug testing that impacts your programs, right? These laws that are being passed and implemented significantly impact the who, what, when, where, why, and how you can conduct workplace screening, and most importantly, what disciplines can be imposed for those that test positive. You'll see legalese out there that talk about lawful activities or lawful product laws, which existed back in the the cigarette smoking era is now, of course, with marijuana legalized, it's a considered lawful activity under some of those historical laws. Most importantly, there's new prohibitions on uh, a couple states here that talk about testing for non-impairing cannabis metabolites. Where I sit at here in Washington, California, Connecticut have specific rules that are now discerning past use of marijuana versus recent use of marijuana and making that distinction now, testing for the parent drug analyte, which we're not going to deep dive into that today. That's a whole other
No,
presentation, but
but I will mention in that vein, Nick, that Arizona's law says that a medical marijuana patient cannot be, there can't take any action against them and because of a positive test unless the test revealed impairing levels of THC. What is that?
yeah,
I don't know if anybody knows what that is.
again, the topic of marijuana is its own presentation in of itself. But what we really wanted to harp on is the trend that we see. There's 10 states right now that prohibit action based on off-duty use of non-impairing cannabis metabolites or the off-duty use of legal marijuana. There's 28 states that have implied off-duty or language that says, you can't take action unless the use was conducted, well, the use of the illicit substance was done at work.
How do you
Well,
prove that?
yeah. I mean,
How
it's
do
very
you prove that?
I think we all understand that there's no methodology, there's no device, there's no per se limit in the workplace today that you can determine if someone's under the influence or impaired by marijuana. That's why we're huge proponents of oral fluid drug testing, which is the drug screening methodology with the shortest detection time period that closes that detection window and more correlates use while at work versus the other specimen methods that are available today. So, Bill, I mentioned marijuana, it's its own discussion. For time purposes, we're going to move on. But when we talk about the law, can you craft the picture of what all those,
Yeah,
everything goes into the being the law?
folks are often confused about what the concept of the law is. The law isn't just a state statute. It's a state statute, regulation, and court or agency decisions all wrapped into one. That dictates what you can do. But we see policies all the time where people just basically took out the state statute and rewrote it or put it down with their letterhead, their logo on it. That's not going to get you anywhere. And we're going to show you in a moment how there are great differences between like statutes and regulations and court cases and how they
Yeah.
differ.
Yeah, I mean, you have lawmakers out there and voters that create bills, that pass laws, obviously that impact workplace drug and alcohol screening. The language of those laws is something you need to understand from a policy perspective, but how the regulations are adopted, the details of those laws as they're defined now become your procedures, right? Same thing with case law. It now creates a legal precedence that needs to be understood and implemented. And we mentioned we're going to talk about a couple different states, both our friends in Minnesota and Oklahoma. So, Bill, in brief, just summarize the different requirements that
Yeah,
are out
we'll just go through this very quickly, and you're going to get a copy of these slides anyway. You can go through it in some detail and call us if you have any questions. But there are a number of states that require employers to do testing according to a written company policy. And they go so far as to tell you what that policy's got to include. Like in Minnesota, it says that policy must identify the employees and the applicants that are subject to testing, the circumstances or the when, as Nick was talking about, drug testing will take place. The right of an employee to refuse. Now, that's key. It's got to be written right in your company's policy. And there are a number of states that have that requirement. So pay attention. Your policy has to dictate in Minnesota exactly what the disciplinary action is going to be, the right of the employee to explain or object, I suppose, and the right of the employee in Minnesota to have a retest and to request a retest. Now they have to pay for it, but they have the right to do a retest. In addition, there are posting or notice requirements, how you present your policy to employees and applicants. That is all detailed in the state statute.
Another oddity out of Minnesota. Minnesota is one of those states out there that you're not allowed to terminate someone the first time they test positive for an illicit substance. You must first offer them the opportunity to go through a treatment program and return to work, but prior to taking any adverse employment action. So again, those are the things that could catch you off guard if you're not aware of the state statute. And I'll cover the next state, Oklahoma here, which is very, very similar, right? Where the policy is required. Another state that it must be written, and then they pretty much tell you in the statute, exact or in the regulations here on what you need to include in your policy. A statement of why you're doing it, who it applies to, the circumstances on when testing's taken place, what substances you're going to test for, what methodologies you're going to use, what are the consequences. All those different things must be considered, right? And then also they have very detailed rules on how the policy is implemented and delivered and posted and noticed to all those that it applies to. So those are the details that'll catch you off guard that you need to be aware of when you go to craft your policy, implement it, update it, etc. So, Bill, our favorite section here is the
Yeah.
voluntary laws, right? I really want to harp into this one because as Bill's famous for getting up on national stages and kicking and screaming, saying, this is where the money is, this is where the ROI is in your workplace drug testing
Well,
program. So,
I'm a lawyer. I want the money. The money is important. But people often don't realize that when they create a drug testing policy and it fits the guidelines of these state programs, that they are a financial benefit to the company. If you're in any of these states and you're not taking advantage, you're just leaving money on the table. But when I talk about voluntary programs, in addition to the state's workers' comp premium discount programs, there are states with where you can defend or even defeat a work comp claim based on a positive test. The premium discount programs, the unemployment programs, and the immunity statutes. You're immune from being sued. Well, who wouldn't want that?
Yeah. Here are the 12 states that offer employers a discount on their work comp insurance premiums, which can be pretty hefty these days, by simply having a drug screening program in place that meets the rules in those states.
Think
Uh,
about how you're trying to justify the existence of your drug testing program and the cash you're laying out for that. Wouldn't it be great to get 5% back on your premium for workers' comp? That helps justify your program.
Oftentimes, yeah, you're right. Those cost savings cover the entire cost to operate your drug screening program, especially when you consider the 21 states that Bill will say will offer the rebuttable presumption of intoxication
It,
defense, essentially where if someone tests positive in a incident work comp situation, they're presumed that drug use caused the accident, thus denying claims in most part.
I was inclined to beat on the table here because if you're in one of these 21 states and you're not taking advantage of these statutes, these rebuttable presumption statutes, you are committing malpractice. In
Leaving
my
money on the
opinion.
table at
Yeah,
least.
absolutely commit. Yeah, I was going to say something else,
Yeah, I
but
know.
you're committing malpractice here. And let me explain the basis of this. Since workers' comp started way back in I think 1913 was the first year workers' comp existed in any state in this country. It was passed in New York, but it actually started in Wisconsin. Anyway, not long after that, a defense to a claim started to arise across the country. But in order to defeat a claim based on an intoxication defense, you had to show two things: that the employee was intoxicated at the time of the injury, and that the intoxication caused the accident or the injury. Those became very, very difficult to prove. Well, as the mid 1980s, late 1980s came along and drug testing evolved, legislators start to realize, hey, here's something we can use to defeat those two concepts. And so the states began passing these laws. Now we have 21 that basically presumed those two elements you otherwise had to prove. And so you got to take advantage of
Yeah,
these state statutes.
totally agree. We also round out, Bill mentioned earlier, some states that have requirements for specific industries, public work contractors, home health care workers, child care workers, those that operate taxis or shuttle buses, school bus drivers and bus assistants, prison transports, and of course, Bill mentioned already his favorite bungee jump
Yeah.
operators, carnival ride operators. Just understand if you're in some of those specific industries, there may not be a mandatory state law, but there could be laws specific for those different job
Yeah.
types. Then, of course, immunity laws, we've harped on that a little bit. If you simply follow the different voluntary programs that are out there or the immunity laws out there, you're immune from lawsuits based on taking adverse employment action. Again, probably the cheapest insurance policy you'll ever have as an employer.
Yeah, if you're in Alaska or Arizona or Iowa, all of these states have immunity statutes or provisions for immunity within their mandatory state statutes. So take
And
advantage.
then sadly, the shrinking number of states that we consider open states, they have no mandatory laws, rules, regulations, statutes, case law. Employers are simply encouraged to follow best industry practices there. Okay, Bill, I love this slide because this is always the call that we get. Something hit the fan. What do we do? Somebody tell me what to do, right? And this is where
Yeah.
we talk about procedures. You can craft the best policy ever. You can pay the most expensive lawyer out there to craft this policy and implement it, but it becomes nothing unless you have the procedures that complement of the policy, right, Bill?
Well, absolutely. I mean, the policy becomes nothing more than pieces of paper unless you follow and implement procedures properly.
Yeah.
And
So
in a lot of states, they have very detailed procedures. The state of Hawaii, state of Oklahoma, North Carolina, They all have very detailed procedures that you have to follow, and they may differ from the language in the state statutes, as I'll show you in the next slide.
So these are things like distribution of policy. It's not going to be something you're going to detail in your policy, but it's a administrative item, how the policy is distributed or posted. What state or local limitations are there? Acknowledgement, whether it's required or whether it needs to be written. We talked about notice of the policy, where testing is going to occur. Your staff needs to understand how testing is conducted. That may not be something that you detail to the specific degree in your workplace policy. How to handle refusal to tests. Who's your medical review officer and what's that communication process? How are test results reported? What do you do when someone says that they want to challenge a positive drug test result? How do you handle adverse employment action based off of a positive drug test? All those procedural items is what you need to detail for the day-to-day operation of enforcing the rules within your company policy. So,
Here's
Bill,
a slide,
yeah,
yeah,
go
here's
ahead,
a
go ahead.
slide where we can show you exactly what we've been talking about in terms of state statutes differing from regulations, differing from court cases. Here are just a few examples for you. In the state of Oklahoma, the state statute listed there on the left-hand column defines what a drug is, and it defines the categories of drugs. But then if you look on the right-hand column there under Oklahoma, you can see the regulations limit you to schedule 1, 2, or 3 drugs. If you don't follow that regulation or don't know the regulation exists, you might violate somebody's statutory rights. And there was a well-known case, the Creekmore decision in Oklahoma, where the employee tested positive and she ended up positive for a Schedule 4 substance. Well, she won in a lawsuit when she filed a claim against her employer. North Carolina. We were talking about this with a customer just yesterday. The statute does not even mention the word notice, but the regulations require employers to provide notice twice in the life of the drug test: pre-test notice and post-test notice, both of which are designed to inform the person being tested, the examinee, as it's called in North Carolina, of their rights. Okay, so if you didn't know these regulations exist, you would violate their rights under state law. And then finally, in Iowa, Iowa has a definition of what an accident is. It's kind of detailed. It's a Chapter 88 reportable injury involving damage to property, etc. But the regulations go even further, and the court cases even further than that. There was a court decision in a case involving a woman being treated for carpal tunnel, and a new HR person came in after she'd been getting treatment for carpal tunnel for almost a year. And this new HR person said, well, she's going for treatment, she's got to be drug tested. Well, she refused. She filed a lawsuit after being disciplined, and she got $40,000 because the state appellate court said carpal tunnel and other soft tissue injuries aren't considered accidents. And
Yeah.
Nick, I can't see with my old eyes. Read that section of what
Yeah.
the court said.
In brief, it said the Iowa Supreme Court has defined accident as a sudden event or change occurring without intent or volition through carelessness, unawareness, ignorance, or a combination of causes, and producing an unfortunate result. As
That was
Bill,
that's my favorite line.
yeah,
Producing an unfortunate result. Okay,
yeah.
that's an accident. So
So all those things need to be considered. That's why we talked about not just looking at the state statute, the regulations, case law. All those things come together to become the law, and all need to be considered when you're forming a policy and your procedures. The last topic we wanted to touch on today is the critical role of job descriptions. Job descriptions used to be an HR nightmare where it's just an administrative thing where you want to go hire somebody, you go craft a job description, and you go post someone to hire. So the weight of these job descriptions and the emergence of marijuana laws hold more weight than ever before, especially for those employees you're going to be considered safety sensitive, trying to take advantage of the safety sensitive carve outs to these rules that exist in most jurisdictions. You
yeah,
can't
and
just say that all your employees are safety sensitive, right,
yeah,
Bill?
you can't do that. And you need to be detailed. You can't simply say this job safety sensitive and move on. You have to explain why it's safety sensitive. And one last real quick hint, the state Supreme Courts of Minnesota and Iowa have both determined that it's not the environment that determines safety sensitive nature. It is the specifics of the job. So you can't simply say everybody in this warehouse is safety sensitive. That won't work. You
That's right.
have to prove why each job is safety sensitive.
If someone's a floor manager at a warehouse, but at any time during their day to day, they could be required to go hop on a forklift, detail that, make sure that's detailed. If you're in a kitchen environment, hospitality environment, you're around hot liquids, sharp knives, slip and fall accidents, make sure you're detailing the essential functions of those jobs so that it's not if you ever get challenged in the court of law, but when you can defend that stance. And again, especially for those employees you're going to designate as safety sensitive, and make sure again they're written job descriptions. This is something that's again, I saw it was kind of a rudimentary or administrative task, but with different marijuana laws out there and how they're limiting employers, taking advantage of those safety sensitive carve outs is critical. But again, you must be confident when you designate those employees as safety sensitive. Okay, I know we threw a lot at you today. We were talking a little bit fast, but I wanted to wrap with some guidance and action items, and then we'll close and get to some questions here. So, if we haven't made it painfully obvious today, make sure you clearly understand the language to contain in federal, state, and local laws that impact the what you can do in each of the states that you operate in. Make sure you please create, implement, and routinely review your drug-free workplace policy. You can see this stuff changes rapidly and is incredibly impactful. Make sure you have a company stance on anybody who violates the policy, especially dealing with the changing rules with marijuana testing. And stay up to date with all the regulatory decisions, case law. Find a partner in this space to help you take that off your plate. Make sure you've designed and implemented sound processes and procedures that complement the language of your policy. This removes any guessing for your managers and staff in the heat of the moment, and obviously provide that information to your employees so they understand what they're being held to. Make sure you review the different drug screening methodologies and products that you're utilizing and whether that might differ pre-hire from post-hire, and make sure that they comply with the states and jurisdictions that you operate in. We are huge proponents of providing managers and supervisors with training, not only on the details of your company policy and your procedures, but also, more critically, I think, train them on how to properly recognize the signs and symptoms of workplace substance use and what action steps they should take in the heat of that moment, and how to document that situation so that they cover their derriere just in case something happens several years later that they need to go back and refer on their notes. Between oral fluid drug testing and reasonable suspicion supervisor training, those in combination is really the best insurance and investment a employer can make considering the legal landscape of workplace drug screening today. Make sure you have job descriptions, make sure they're detailed and comprehensive, make sure you review those, and especially for those that are safety sensitive. With regards to medical marijuana, one quick shout out here. Make sure that you're prepared to engage in the interactive conversation to determine if that medical marijuana user who is legally authorized under state law to use the marijuana as a medicine, make sure you can reasonably accommodate their underlying medical conditions or not prior to taking adverse employment action. It's a huge step. Critical 2 or 3 minute conversation that can save you a ton of money versus just blindly terminating or taking adverse employment action there. And then finally, we talked about this earlier. Drug testing programs aren't a gotcha, type of thing. You're a substance user, go kick rocks. Employers now more so than ever are looking at different ways to find a balance between the lawful use of these substances and workplace safety and maintaining a good employee. So consider things like treatment options, second chance agreements, reasonable accommodations, those types of things in your policy. I think to retain good employees, we know it costs a lot more money to go hire somebody than it does to retain a good employee. So with that, we will go ahead and wrap our conversation. I'll go ahead and bring Ryan back in to close us out, and then we'll take a look at some questions.
Actually, Nick, if you don't mind, we can get to some Q&A first, and then
Do it.
I'll close this out. I just need about 3 minutes. Also
Good.
keep in mind too, we've got some great questions, 12 now, 11, 12 questions. If we can't get to them all, everybody, Nick and Bill have graciously extended the offer to answer them, and we could answer those in a follow-up email. Okay, so let's see what we can get to in 3 to 4 minutes.
So Bill, here's a great one for you. What's the definition of safety sensitive?
Ah, well, there are probably, if I have to guess off the top of my head, about 24 states that define safety sensitive. They typically involve those kinds of jobs that could result, if you are using a substance, could result in injury to someone or the employee themselves. But we have a chart on that. More than happy to share the chart. So if you need state by state definition, we've got a 50 state chart on that issue of what
But
safety
it's a
sensitive.
great question, and I'm glad it was asked because,
Right.
of
Well, and
course,
you got to be real careful, especially with marijuana laws. They tell you whether you can or can't take action, provided it's a safety sensitive job. Okay, well, what is that?
let's see what else we got here. Does off-duty use impact a positive post-accident drug test? Um,
Ugh, well,
it's tough,
uh,
right?
yeah, this is where we get into an incredibly complicated, detailed scientific answer. And I actually was dumb enough to own a laboratory for a while, but I still don't know that I'm qualified to answer the question. Essentially, very briefly, if you use marijuana, and I used to say smoke dope until my son kept laughing at me with that. If you use marijuana, it breaks down into your body first is something called delta 9 THC. Then within a matter of hours, it breaks down into another substance called hydroxy THC. And again, within a matter of hours, that breaks down into what's called carboxy THC. Well, of the three of those, only two, uh, delta 9 and hydroxy, are psychoactive. Okay, so and carboxy is not psychoactive. And we have a number of court decisions that literally say that carboxy is a negative test result because it's not psychoactive. The Arizona Supreme Court, for instance, reversed a DUID case because the state lab reported a positive of carboxy, and the court said it's not psychoactive, it's not impairing, so we can't convict the guy on that. In California, state of Washington, they require you show a psychoactive metabolite of marijuana. So you
Yeah, and
can't use carboxy, meaning you can't test using urine if you want to take action in California. Why? Because urine can only detect carboxy, the non-impairing substance.
Yeah, Doug asked a great question at the kickoff of our conversation of how you find that balance between illicit or lawful drug use and workplace safety, right? And then also he added in the Q&A here, how can you distinguish between someone being under the influence or not? Or, since there's a lack of device, lack of methodology, again, I'll reiterate that if you haven't looked into oral fluid testing, put that on your to-do list today. Oral fluid drug testing has the shortest detection time period and is the only methodology available today other than blood testing to detect delta 9 THC, the
Well,
active psychoactive substance,
and
right?
I would go even further, and we went very quickly past the slide that said that there are 10 states that specifically prohibit discrimination for off-duty use of lawful product marijuana. But then there's 28 states that say that employers are only allowed to take action if they find the employee to be using or under the influence. How do you do that? Well,
So I
you
think,
can't do that with urine.
you know, so again, the answer there, oral fluid and reasonable suspicion training, you have those two tools right there, the best tools that employers can employ right now.
Fantastic, gentlemen. I think that's a good place to stop. I know there were a lot of questions that we couldn't get to, but again, we'll work with Nick and Bill behind the scenes, get those answered and get those sent out.
Absolutely.
Excellent information. Clearly, a need for a follow-up webinar. Gentlemen, if you're up for it, perhaps 90 minutes and perhaps
Always.
early 2026, we could revisit this.
Absolutely. There will be changes even in this short.
Always. Excellent information. For all of you listening in, please let us know what you thought about today's webinar by completing the post-webinar survey. A survey link will be posted in the chat here shortly. It will also be sent out in the email with your certificate of attendance and a PDF copy of the slide deck. Next, as promised, look in the chat for your HRCI and SHRM activity IDs. Again, these will also be on your certificate of attendance. If you have additional questions for Nick and Bill, something comes to mind later today, tomorrow, next month, next year, which isn't too far off, go ahead and reach out to them. Their information is on the screen. I also strongly encourage you to reach out to your local ArcPoint Labs provider, especially if you have questions about supervisory training, oral fluid testing, as Nick and Bill emphasized a moment ago, something that's very much within our wheelhouse. For those new to the ArcPoint brand, we offer a suite of employer solutions that help prevent, identify, and manage a variety of workplace risks. All right, our services include, but are not limited to, policy development, drug testing, random program management, supervisory training, DOT physicals, background screening, OC health, employee assistance programming, and the list goes on. To learn more about these employer solutions and others, check out the employer solutions page on ArcPoint's website, www.arcpointlabs.com. If you're interested in a free consultation with an ArcPoint representative, you can fill out the form on the employer solutions page and somebody will get in touch with you, or simply reach out directly to your ArcPoint Labs provider. All right, we are 1 minute away from the top of the hour. Nick and Bill, any closing comments or takeaways you'd like to share with our audience?
Yeah, just a closing comment would be, again, that this is not, it feels like mission impossible to some HR employers out there to comply with all this stuff, right? So again, please understand the language and laws that are out there. Empower yourself to understand what the rules are. That's your blueprint for success. Look into oral fluid. We think that it's, Bill mentioned earlier, best thing in our industry since sliced bread. Keep abreast of the different technological advancements and emerging technologies that are coming into the workplace drug testing. And then please, 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 reasonable suspicion supervisor training, a free insurance policy for you. Empower your managers and supervisors on how to recognize those signs and symptoms. And it's permissible to take employment action and reasonable suspicion situations in every state in our country.
Awesome. Well, thanks so much, Nick. Bill, thank you so much. On behalf of the entire ArcPoint team, very special thank you to our partners at Drug Screening Compliance Institute, Nick Hartman, Bill Judge. Thank you all so very much for your time today. Thank you for your great questions. We will attend to them and get back to you. And keep an eye out in your inbox for the next Thrive webinar. All right. Enjoy your Thursday, everybody, and we'll see you again soon.
Thank you.